Hi friends, good morning. Welcome to Shankaranaya Study Circle. This is Dr. Harinath Reddy, Director of the Institute. Today in this particular video, we will discuss about the constitutional validity of central formulas. The constitutional validity of the central formulas and even the arguments which are against the central formulas and also the arguments which are in favor of central formulas. And the ongoing standoff between the government and the farming community, with the protests being held in outskirts of Delhi on these central formulas. So let us see what is good and what is bad in these central formulas, and also one more dimension, the constitutional validity of these central formulas. Remember this video and article, it is based on an article written by Faizan Mustafa, the Vice Chancellor of Hyderabad Nalsar Law University in Hyderabad. So Faizan Mustafa is very greatly informed constitutional expert on Indian Constitution. He writes very frequently on constitutional issues, and this article is based, this video which we are discussing is based on an article written by Faizan Mustafa. See, the three central formulas which were enacted by the Parliament, Indian Parliament, were challenged before the Indian Supreme Court to look into the constitutional validity of these laws. See, the question is, if you see the 7th schedule of the Indian Constitution, which provides for the distribution of powers between the center and the states, the executive powers, legislative powers and financial powers are divided between the central and state governments in the 7th schedule in the form of three lists. List 1 is union list, list 2 is a state list, list 3 is concurrent list. So there is a opinion that agriculture, the laws which are made by the Indian Parliament in the recent past, they pertain to the subjects which are mentioned in the state list, and the Indian Parliament making laws on the items which are in the state list amounts to encroaching into the domain of the states. So there is one opinion which says that these laws are constitutionally invalid because Parliament has made these laws and the Parliament doesn't have an authority or competence to make such laws. Let us see this argument in greater detail. See, what are the broad arguments against the laws? So, why people are worried about these central formulas? What are the broad arguments in favor of these laws and against these laws? Let us see the arguments made by government. Government says that these laws will transform Indian agriculture and attract private investment. True. Even this opinion is in agreement with the views expressed by Dr. J. Prakash Narayan of Lok Satta in Andhra Pradesh, and even Ashok Gulati, the ex-chairman of Commission for Agricultural Costs and Prices. So they agree with this argument of Government of India. So Government of India claims that these acts will transform Indian agriculture and attract private investment. Remember, in India, around 50% of the people, they are dependent on agriculture and related activities. So 50% of Indian population is dependent on only 15% of the national income, 1/5. So agriculture and allied sectors, they contribute roughly 15% to the national income. In other words, half of the Indian population is dependent on less than 1/5 of the national income. So which means this speaks about the agrarian distress in the rural areas and also the low incomes for the people who are dependent on agriculture and allied sectors. So far in the last several decades, the agriculture is subjected to controls and regulations. And remember, in 1991, when economic reforms were taken up, the industrial sector and the service sectors were liberated from the from the fetters of the government, and as a result we have seen phenomenal growth in the service sector and even in the industrial sector. But unfortunately, it is the agriculture sector where the reforms were not taken up, and these reforms were long overdue for the last 3 decades, and it is just a beginning. These were the arguments made by Dr. Jayaprakash Narayan and even Ashok Gulati, who was earlier the chairman of Commission for Agricultural Costs and Prices, and these arguments made by these experts, they are in tune with what the government is claiming. The Farmers Empowerment and Protection Agreement on Price Assurance and the Farm Services Act 2020. The Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Act 2020. It provides for contract farming, under which farmers will produce crops as per contracts with the corporate investors for a mutually agreed remuneration. So, it was said that this law, which encourages contract farming, will help the farmers because at a predetermined price, the farmers will be producing the crop without any risk of price instability, and even many a times the corporates, they provide all the needed inputs to the farming community, thereby reducing the burden of the farmers to spend for agricultural inputs. But the farmers who are protesting, they fear that powerful investors would bind them to unfavorable contracts drafted by big corporate law firms with liability clauses that would be beyond the understanding of poor farmers in most cases. This is an unconfounded fear because if the terms in the contract are not favorable to the farmer, it is not necessary for the farmer to enter into contract farming. And to aid the farmers, even in India, they can take the services of the advocates or even the legal advisors to read into the contract and see whether the clauses they are in favor of them. This is eminently possible, but those who are against these central laws, they create a fear in the mind of the farming community that the terms of the contract may be unfavorable for you, it will be beyond the understanding of the farmers, which is not true to a great extent. And similarly, the another legislation, the Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020, liberates farmers by giving them the freedom to sell anywhere. So in other words, another legislation which is a part of the central farm laws, it will give greater freedom to the farmer to sell his produce anywhere in the country and even outside the country to realize a better price. And this again, it goes in favor of protecting the interests of the farmer. Many a times under the existing laws like APMC Act and even Essential Commodities Act of 1955, the farmer is denied the freedom to sell his produce at a place where he can realize a better price. So because of the controls fetters which were imposed on the farmers and the farming and the agricultural produce, it is the farmers who have lost. And according to a study done by OECD, the average increase in the farm incomes is zero in the last 3 decades, which means it speaks volumes about the extent to which the farming community has lost for the urban community. So I told that 50% of the Indian population, they are dependent just on less than 1/5 of the national income. So to keep the prices within affordable means for the consumers, the farming community got hurt very badly, and as a result today we have huge agrarian distress where the farmers are committing suicide. And definitely this is not good for a country where 50% of the population is dependent on agriculture, and if you depress the prices of the agricultural produce, it is not in the long-term interest of the country as well. And regarding this legislation, the Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020, the opposition political parties say that this would lead to corporatization of agriculture. And see, corporatization of agriculture, there is good and bad. So we have to see that ultimately the good comes to the farming community and the bad had to be handled by the governments, both the central and the state governments. And just because of the fear that Indian agriculture gets corporatized and the farmers will be advantaged because of these unconfounded fears, it is not fair not to give an opportunity for the farming community to realize a better price for their agricultural produce. And those who are opposed to the central farm laws, they say that even now the farmers can sell outside the APMC, and in fact they are doing that. But remember, the farmers, even if they sell outside the APMC market, that is not being done as per the law, and it is not illegal. And in addition to this, without getting any service in return for the cess which they pay outside the APMC market, it is unfair. For example, even in the agricultural produce market committee yard, if the farmers go and sell there, they are paying a number of fee. For example, if you take the states like Punjab and Haryana, the market fee in Punjab is 3%, rural development fee is 3%, and the commission of the commission agent is 2.5%. In other words, 8.5% of the value of the total produce is being paid to government or the commission agent. And similarly in Haryana, 2.5% is the market fee, 2% is the rural development fee, and the commission of the agent is 2.5%. So roughly 6.5% the farmer is losing without no proportionate services being provided in the market yards of the government sector. See, many a times the infrastructure in the agricultural produce market committee yards is very, very poor. Even if the women farmers go there to sell their agricultural produce, and if they are compelled to stay there for 1 or 2 days, they don't have proper accommodation and toilet facilities as well. So, but the government, they have been collecting this cess, market fee and cess for improving infrastructure in these markets for several decades, but not much is spent on improving the infrastructure. So AP Agricultural Produce Market Committee yards, they are in a very poor state of affairs without much being spent on. So it is very, very unfair to collect the market fee or cess without spending that money for improving the infrastructure in the APMC market yards, benefiting the farming community. So the existing status quo is unfair and it is at a huge disadvantage to the farming community. And one argument which is raised is, through these market fee, rural development fee and the commission to the agents, the governments are getting huge revenue, and as a result they are against these central farm laws. For example, it was said in the states of Punjab and Haryana, these two states, they get around 3,500 crores and 1,600 crores respectively each year from these cess. But the existing laws, but the central farm laws which were enacted by the Indian Parliament, they do not allow the state governments to levy such fee for the agricultural produce which is sold outside the APMC Act. If that is the case, probably the states may fear that they may be losing revenue which they are getting till now. But the welfare of the farmers is much more important than the state governments getting revenue or realizing revenue by charging the fee which I discussed. And then let's move to the constitutionality of these laws. In 1972, a case which went before the Indian Supreme Court known by the name Union of India versus H.S. Dhillon. In this case, the Supreme Court said the laws made by the Indian Parliament can be challenged before the Supreme Court on two grounds. One is if the Parliament, whether the Parliament has the competence to enact such laws, whether the Parliament has the jurisdiction to enact such laws, and whether the laws enacted by the Parliament, whether they are in a violation of the fundamental rights. In other words, invoking parliamentary powers on agriculture. See, all these central laws which are made by the Indian Parliament, they relate to agriculture, and agriculture is primarily a subject in the state list. So is it fair enough for the Parliament to make laws on a subject in the state list? Is it not against the Constitution, the constitutional provisions? So that's a question which was raised. Does Parliament have the power to enact laws on agricultural markets and lands? And should the Constitution have been amended before enacting these laws? Even if at all the Parliament wants to make laws, the Constitution should have been amended earlier. And then if you see, these central formulas which were enacted by the parliament recently, they do not mention in the statement of objects and reasons the constitutional provisions under which parliament has the power to legislate on the subjects covered. Usually, in any central law, in the very beginning, there is something called the objects and reasons, the statement of objects and reasons, in which it will be clearly spelled out under which provision in the Indian Constitution Parliament has made the relevant law. But that was missing in these central formulas is one more criticism. Then federalism is one more idea which was brought in by Faizan Mustafa, and he says that if the center makes a law on a subject which is given to the states, then that amounts to undermining the federalism. Federalism is essentially, it is meant for, federalism essentially means both the center and the states have the freedom to operate in their allotted spheres of power in coordination with each other. And remember, earlier in the beginning, Supreme Court said that the Indian Constitution is not federal, but in course of time, there was a change in the viewpoint of the Indian Supreme Court. In S.R. Bommai versus Union of India case of 1994, a 9-judge bench of the Indian Supreme Court held that federalism was part of the basic structure of the Constitution. Though the word federal is not mentioned anywhere in the Indian Constitution, the Supreme Court said that India is federal, and federalism in India is not just a matter of administrative convenience, but it is a matter of principle. Even the Parliament, under Article 368, through a constitutional amendment, cannot take away federalism. In other words, what does this mean? Parliament must respect the legislative competence of the states and the areas which are given to the states in the state list. And though federalism, like constitutionalism and separation of powers, though it is not clearly explicitly mentioned in the Constitution, it is the very essence of our constitutional scheme. Then let us see whether the Parliament had the competence to make laws on agriculture. Terms relating to agriculture, it has occurred at 15 places in the 7th schedule. I told 7th schedule deals with the distribution of executive, legislative and financial powers between the center and the states. And you know that the union list contains 98 items, the state list contains 59 items, and the concurrent list contains 52 items. So in the 7th schedule, the term agriculture is referred at 15 places. For example, in the union list, entries 82, 86, 87 and 88, indirectly they have a reference to the term agriculture, and they say that 82, 86, 87 and 88, they say that there are certain taxes which are levied by the union government on income and assets other than agriculture. That is non-agricultural income. On non-agricultural income, the taxes can be levied by the union government. This is indirect, but if you see the state list, in the state list there are 8 entries related to agriculture. For example, entry 14 in the state list, it is related to agricultural education and research, pests and plant diseases. Similarly, entry 18 in the state list, it deals with the rights over land tenures, rents, transfer of agricultural land, agricultural loans. They are dealt by entry 18. Similarly, entry 28 in the state list, it deals with markets and fairs. Entry 30 deals with agricultural indebtedness. Entry 45 deals with land revenue, land records. Entry 46 deals with taxes on agricultural income. Entry 47 deals with the succession of agricultural land. And entry 48 deals with the estate duty in respect of agricultural land. And here you can see the detailed areas where the state legislatures have competence. And similarly, in the concurrent list, there is one entry 41, which deals with evacuee property including agricultural land. So from the above, it is clear that the union list and concurrent list put matters relating to agriculture outside parliament jurisdiction and give state legislatures exclusive power. So which means agriculture is primarily a subject in the state list, and the state legislatures have the legislative competence to enact laws, and the parliament doesn't have the competence to make law. That is the summary or the takeaway from the earlier 2 paragraphs. And even entry 27 in the state list, which deals with the production, supply and distribution of goods. In the state list, There is one entry by name entry 27, and this entry 27 deals with the production, supply and distribution of goods, and this is the only entry in the state list which is subjected to entry 33 of concurrent list. So there is something in the concurrent list in entry 33, and what is there in entry 27 is subjected to and limited to what is there in entry 33. Then what is there in entry 33 we will see. In the concurrent list, entry 33 deals with the trade and commerce and also the production, supply and distribution of certain commodities like foodstuffs, like edible oil seeds, oils, cattle fodder including oil cakes and other concentrates, raw cotton, raw jute, etc. So with respect to these items, Parliament has the power to regulate trade and commerce and also the production, supply and distribution. So entry 33 of the concurrent list mentions the trade and commerce, production, supply and distribution of domestic and imported products, and the Parliament has control in the public interest on the items like foodstuffs, cattle fodder, raw cotton and jute. So therefore the centre argues that it is within its power to pass laws on contract farming and intra and interstate trade and prohibit states from imposing fee or cess outside APMC areas. But it was argued that foodstuffs are different and agricultural. See, like education, farming is an occupation, not trade or commerce. Like education, farming is an occupation, not trade or commerce. If foodstuffs are considered synonymous with agriculture, then all the powers of states in respect of agriculture listed so elaborately in the constitution shall become redundant. So the government of India very cleverly has interpreted what is there in entry 33 of the concurrent list to extend it to agriculture, thereby making an argument that Parliament had the competence to make such laws. But Faisal Mustafa argues that if what is there in entry 33 like foodstuffs are considered synonymous with agriculture, then all the powers which the states are given will be taken over by the Parliament, and the states will be made powerless. And there are certain cases which were dealt by the Indian Supreme Court to resolve the disputes of that nature. For example, in 1959, in a case known by the name State of Rajasthan versus G. Chawla, courts have used the doctrine called the doctrine of pith and substance to determine the character of legislation that overlaps between entries. So if there is a law made by Parliament or state legislature, and if that legislation overlaps into the areas of both state list and also either the concurrent list or the union list, then how the issue has to be resolved. The constitutionality of legislation is upheld if it is largely covered by one list and touches upon the other list only incidentally. For example, if a state legislature had competence to make law on a particular issue in the state list, any such law made by the state legislature on that particular issue, if it primarily falls in the state list, if there is only incidental encroachment into the other list like the concurrent list and the union list, then such law will be constitutionally held valid. But here the central formulas enacted by the Indian Parliament, it is argued, they don't incidentally encroach into the state list. They entirely take away the powers of the states, so they cannot be constitutionally protected, which means they have to be declared as constitutionally invalid. For example, the Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020 conflicts with entry 28 of the state list, markets and fairs. Similarly, the Farmers Empowerment and Protection Agreement and Price Assurance and Farmers and Farm Service Act 2020, this is a central law made by the Indian Parliament. It impinges on entries 14, 18 and 46 of the state list and entry 7 of the concurrent list. So in interpreting the list, the Supreme Court in state of Bihar versus Kameshwar Singh invoked the doctrine of colorable legislation. What does this doctrine of colorable legislation says? What you cannot do indirectly, what you cannot do directly cannot be done indirectly as well. For example, there was an argument that these central formulas which are made by the Indian Parliament, that is a subject in the state list, which means the center cannot do directly. So what is prohibited to be done directly cannot be done even indirectly. So the Supreme Court, by depending on an interpretation to entry 33 in the concurrent list, thought that it has a jurisdiction with respect to the agriculture and other related areas which are mentioned in the state list. So it is by applying the doctrine of colorable legislation, the Supreme Court can strike down these central formulas as constitutionally invalid. And similarly, in 2002, in one of the cases which went before the Supreme Court, ITC Limited versus APMC, the Supreme Court upheld the validity of several central laws relating to agricultural produce marketing and struck down the Central Tobacco Board Act 1975. And then the committee headed by Ashok Dalwai and Ramesh Chand, even see the opinions of the committees appointed by the Government of India. The committees headed by Ashok Dalwai, this was a committee on doubling the farmers' income, and Ramesh Chand, they have recommended that agricultural market be entered in the concurrent list. So there were committees appointed by Government of India making a recommendation to include agricultural market which is presently in the state list to be included in the concurrent list. What does this mean? So it is very clear from these recommendations that foodstuffs under entry 33 of the concurrent list do not empower Parliament to enact laws on agricultural markets. So agricultural markets, it is a subject in the state list, which means the center doesn't have the competence and the power to make laws on agricultural marketing. And even the committees appointed by Government of India, they have recommended to include agricultural marketing in the concurrent list. Once this is done, Parliament will get a power to make laws on agricultural markets. And similarly, even Swaminathan Commission, National Commission on Farming Community, in 2015, May 5th, has recommended agricultural market to be included in the concurrent list. But in 2018, on March 27th, the government in Lok Sabha told that it has no intention of inserting agricultural market in the concurrent list, which means the position is agricultural marketing is in the state list and only the state legislatures have the competence to make laws on agricultural marketing, but the Parliament doesn't have that competence. But recently all these three central formulas which were enacted, they were enacted against the spirit of the 7th schedule and also the letter of the 7th schedule. It is nothing but an encroachment into the legitimate spheres of the state government. This is the view expressed by Faisal Mustafa. Thank you.